Oh, is
Like today.
there an app that will tell you whether this discontinued road will actually get you to where you want to go?
Yeah.
No, but for right now, we need an app to tell us if there's a quorum. I think I count 7 noses of commission members. Am I right, Heather?
Yeah, I see 7. I know Vivian and Joe are out.
Okay. Well, it sounds like we have a quorum. So I'd like to call this meeting to order.
If you need to have a full 7, you might need to count me as 6.5, because I've spent the last 4 nights sleeping out in a tent and the last 4 days running from one lecture to another on common ground and parent grounds.
Oh, yeah,
So
that's right.
Oh,
kind of
well,
How
we'll
was
need
it?
a full report at some point. Yeah.
I'm just gonna check real quick, Jim, on,
This is what happened.
Okay.
on the, not Zoom. I'm gonna check on, and see if I lost anybody because of the confusion with the silliness of the Zoom stuff. So give me one second, let me just check on
Go ahead.
Teams, to make sure I didn't lose anybody.
So that'd be
Just in case.
sorry to not being here.
I don't see anybody over there. Usually it lets me know.
Mhm.
Okay, I think we're all set.
Okay. Let's go with what we have. If anyone wants to join us, they know how to do it.
All right, awesome.
The link. So, okay. So call to order, roll call, please, Heather.
Sure. Jim,
Here.
Kathy,
Yes.
John,
Here.
Carla,
Here.
Chris,
Here.
Vivian is out, Peter,
Here.
Rebecca, out. Roberta,
here, mostly.
Ryan, I think he's out. Steve, I don't see him either. Okay. I'm gonna send them just an email just to double check with them.
Great.
I think we're all set.
Okay. So the first order of business would be the adoption of our minutes from our August 8th meeting. If everyone's had a chance to review those, any comments, changes? Is there a motion to approve the minutes?
I'll make that motion.
Okay, motion by John, second.
Second.
All right. And roll call vote?
Sure. Jim,
Yes.
Kathy,
Yes.
John,
Yes.
Carla,
Yes.
Chris,
Yes.
Vivian's out, Peter,
Yes, even though I'm reading them right now.
yeah, is out, Roberta.
I have not read them yet.
Okay. Do you wanna say yes or you wanna not vote and wait? What's your thoughts?
I trust you people.
Yeah,
Never thought I'd hear that day, Roberta.
Ryan's out, Steve's out, and Joe's out. I'm gonna send that.
Now, Pete, I'll just note that it's lawyers who are supposed to be procrastinators. All right. At our last meeting, we talked about the Group 1 public use draft with regard to the ability to post public easements as well as post town ways to, with regard to putting weight limits on at particular times that might merit it. And that was something this commission voted on unanimously to do. Another thing that the board directed was for us to send a letter to the realtors to let them know about MAPVIEWER. And so included in your packet is a copy of the letter that we sent to Maine Real Estate and Development Association. And that went out explaining to them about the DOT MAPVIEWER tool. The one thing I'd point out to you is just a little bit of a disconnect. There's a disclosure statute that applies to sellers of residential property and commercial property. And it directs the seller, through the realtor, to make the disclosure. And the disclosure is, do you have access on a public way? It isn't, is the access publicly maintained, which is what DOT will tell you with the MAPVIEWER. It's, is it a public way which is more of a legal issue. You know, is it a town way, is it a public easement, or is it a private road? As we all learned and, you know, come to understand those distinctions. So maybe what might be helpful would be to amend those disclosure laws to make them comply or consistent with what DOT has available on MapViewer, and that is whether the road's publicly maintained, not what its legal status is. Hi, Steve. Thanks for joining us this afternoon. We haven't gotten too far down the agenda. We're on really talking about item 4 after adopting amendments.
Okay, thank you.
So,
I just got back from a meeting in Fort Kent, so.
oh, okay,
Jim, can I make a comment on that?
sure.
Back when they were crafting the wording for those two disclosures, they were first going to say, need to disclose if the access was via a private road. And I said, no, here's your opportunity. Say that it's a road that is not maintained by the public, because that will include private roads and abandoned and discontinued roads. And what they did was kind of sort of what I said, but not quite. I think they referred to a definition that says that a public road is a road that is publicly maintained. And so it's, if you read it carefully, if you read the reference, it would correlate with the DOT map viewer, but I think it would be an improvement if we put it right in the law itself, saying a road that is not publicly maintained. And then it would be clear to everyone.
That's maybe something to put in our on our parking lot of things to think about in the future. I don't know if we want to take that on for this session. What do you all think?
It's a pretty simple change. I would think that would be something that'd be worthwhile to do if we get it through.
Yeah, Jim or Roberta, when you talk about this disclosure statement, and are all the details of what's supposed to be in this statement actually written in the statute? Or is it the statute broadly written so it comes out in rulemaking or something?
I haven't got it in front of me. I think what it says is that if the access is not via a public way as defined in, so you have to go and look up the definition. And it would be better to have that definition right within the law so that you don't have to go look someplace else for it.
Okay.
I had those in front of me, but it does mention, I don't have it right now, it did mention the actual, what's supposed to be on the form. So I didn't see that as being subject to further rulemaking, just somebody had to put together a form. But if, you know, we can add that to the list of items where we can prepare draft legislation and take that up at the next meeting. Does that make sense?
Yeah, and Jim, you sent this out on September 4th. Did you get any sort of response or questions or from anybody?
Nope.
Okay.
No, and we're a member of MEREDA, so it's not like they don't know who we are or where the address is.
So the letter has already gone out, sorry. Okay, thank you.
So we talked about, again, about the 29A, 2395 change, about sending the letter. And then we have some follow-ups from the individual groups. What should be added here, and ask for a motion to amend the agenda to add for a review of the Group 2 limited liability draft legislation. Would someone make that motion?
Okay, motion.
A second?
I'll second it.
We'll have to do the roll call vote, sorry.
That's okay. Jim,
Yes?
Kathy,
Yes.
John,
Yes.
Carla. Yes. Chris,
Yes.
Vivian is out. Peter,
Yes.
Becca is out. Roberta,
Yes.
Ryan is out. Okay, Steve
Yes,
and Joe is out.
Okay. Group 2 had been tasked with looking at limitations on liability. And we were looking on something that we'd started last year, and that is to take a look at the limited liability statute. There's one, for example, that we talked about with regard to your own property, so that you can allow people to come on and use your property. Your liability is limited if people come on for recreational purposes. You're not charging them admission to your resort. You're just letting people walk on your property, on an easement. They could hunt, whatever, basically for passive recreation. We adopted that idea and said, okay, there'll be limited liability for repairs and maintenance. There had been discussion at the last board meeting about changing the definition, which I've done, to remove reference to paving. And then what we're saying is that you're not liable if you're the owner, if you're the tenant, if you happen to be the occupant of property that abuts a public easement and you do work in that public easement, to allow folks, yourself or others, to be able to go to your property. You're not liable so long as it's reasonable that you haven't created some kind of, maliciously created some kind of danger to the public. And there's no duty of care that's created by doing this to keep this safe and convenient for access. It's just to allow yourself and others to be able to get to the property. So that's what we've done here. We've made the changes that were requested at the last meeting. And so this came again from Group 2, looking at limited liability. What I'd ask for, we'd included this in the packet for today. I'd ask for a vote on including this in our report. We already have one piece of legislation with regard to, the idea of hosting public easements. This would be the second piece of legislation, or the second concept we present to the legislature. Do we want any discussion on that first before we move to a vote?
So, yeah, I do have a question. Rebecca kept referring back to Title 12. Does this not affect Section 12 or Title 12 or?
No, this is Title 14, and that's where the limitations on liability go. Those are where legal protections are generally discussed in that statute.
But anything we do in here will not affect Title 12.
No. Well, okay, you talked about Title 12, and that's down in subsection 5, and what we're doing is we're trying to protect landowners with regard to environmental damage that might be created by others. We're trying to provide as much protection as possible, and maybe even more than exists in the law currently. And we'll see if DEP wants to push back on that. But the idea is that unless there's some credible evidence that's out there that the person who is the abutter, the owner of property that abuts the easement, actually did something, then we're not going to make that person responsible for fines and violations. The limitation of liability is not just from Jim going down a public easement that's maintained by Roberta and making a claim because of damage to my tire or my whiplash when I hit the pothole. Roberta, I'd never do that. But it's also to protect Roberta from liability for a nuisance that's created by the logging truck that goes through, and that would never happen, but it could. And water goes into the rut and it drains off, and there's a little bit of flash flooding and pollution into a pond, and DEP brings the enforcement action. We want to try to create some protections for the people who are trying to protect the public easement, and it's caused by someone else. Right now, it puts an unreasonable burden on the landowner to try to show who it was that actually did that, when it's going to be difficult to know that the kid with the 4x4 riding through at 3 in the morning on a joyride some summer weekend is the one who put the rut in the road. So we're trying to create some protections there in Title 12.
Jim, I can't remember the statute, but I think it's in Title 17 that allows us to charge someone for abuse of property.
Right, with the nuisance provisions in the old criminal law.
Yeah. That was the one that we kind of go back to if we have an issue where someone drives a 4x4 through a road and does damage.
Right, again, you try and catch them.
Yeah. That's
What we don't want to have happen is have the landowner who's just trying to maintain the public easement held liable when that person causes the damage.
Yep.
For the environmental consequences. Got it. So that's what this does. Any other comments? And if not, are we ready for a vote on this to put this in the stack of legislation we'll provide?
I do have another question, I guess. I see in the title at the end, you have in brackets, not repaired and maintained by a municipality. I'm wondering if that can be removed since it's a more general statute and not, I think it started out, we're talking about, the repairs and maintenance, not maintained by a municipality, but I think that's been removed. So I'm wondering if that can.
Good catch, Carla. Thank you. Let's bold with that change then. With that change, are we ready to entertain a motion to approve?
So by removing that, does that mean that it's either or? I mean, what if it is maintained by the town?
Well, what do you think?
But if they're maintaining it and repairing it, then isn't this a moot point?
Yeah, so Jim, if a town is maintaining a public easement, does the defect law really apply? Because that says town way.
Right. The defect law and the Tort Claims Act, as far as liabilities, probably don't apply to the town's maintenance of a public easement. So the town doesn't need any kind of protection. What we're talking about is where the owner, abutter, tenant, person in possession does work on the road, and you're only going to do work on the road if the town isn't doing it.
Yeah, okay.
I
Well, I
mean,
think, and it seems to me in most of these cases where a town is providing some maintenance, they're not maintaining it year round. I don't know, I'm not one of these towns that does this, you are, so you tell me, are they maintaining these roads year round, or are they just providing winter maintenance, or just providing summer maintenance? If the town is doing all the maintenance, then it seems like this shouldn't apply. But if they're doing some and the landowner is doing some, then the landowner still needs protection.
Pete, what do you think about that? I'd ask everyone else, but start there.
Well, I guess if it's maintained by the town, this shouldn't apply to that. This should apply to what you'd originally intended it to be. Public easement, not maintained by the town.
How about not regularly maintained?
Or not maintained year round by the town?
Yeah, not regularly maintained by the town.
But there are lots of seasonal roads in Maine that towns maintain either the winter only or the summer only. And I gotta believe a lot of those are easements.
And my question is, will this then protect the person who's maintaining it the rest of the year when the town isn't?
Yeah, there may be instances where a town gravels the road once a year, maintains the culvert, but doesn't plow.
Right.
How about without year-round maintenance by the town?
Kind of saying the same thing as what we took out in parentheses.
But we're saying it, maybe we say it in the text under limitations. This section does not apply where a municipality provides year-round maintenance and repair for that public easement.
So in other words, it does apply if it's seasonal.
Yeah, even if it's seasonal, because there are times, if it's seasonal and somebody's going to be using it for a residence, they're still going to need to be able to plow it to get there.
Yep, okay.
So this section does not apply where a municipality provides year-round maintenance and repair for that public easement. We'd put that right at the end of 3 limitations, because this would be a limitation.
So Jim, beginning in Title 14 here, does this also apply to counties? Because it should, same situation, counties that maintain roads.
See, Ryan isn't on to speak up for the counties. Thank you, Pete.
What is Title 14 anyway?
Title 14 is where the Tort Claims Act is. It's where a lot of the legal requirements with regard to actions and court jurisdiction, a lot of that is there.
So it's not the municipal's title or the county title?
Nope.
It's just general, yeah, okay.
General applicability. So yeah, the counties and municipalities are in 30A. So if we wanted to say, yeah, we could say this section does not apply when a municipality or a county
Right.
provides year-round maintenance and repair for that public easement. Again, we'll add that as a limitation under 3. Maybe we can make that 3A and B so that way it's really clear that these are separate limitations, and we'll be right in your face on that. Okay?
Yeah.
So with those changes, getting rid of repaired and maintained by a municipality, not repaired and maintained by a municipality in the title, but making the limitation clear under 3A and B, we have a motion to approve with those changes.
So moved.
Who's that?
Roberta.
Second.
Kathy seconded.
Roberta and Kathy. All in favor? Roll call vote, please.
Jim,
Yes.
Kathy,
Yes.
John,
Yes.
Carla,
Yes.
Chris,
Yes.
Vivian is out, Peter,
Yes,
Rebecca is out, Roberta,
Yes.
Ryan is out, Steve,
Yes.
and Joe is out. Motion carries.
Great. Thank you. So, with that issue on, see, that was group 2 with regard to limited liability. Group 1 has already acted, but group 1 has started to look at another issue, and that's minimum maintenance roads. That's something that Roberta's talked about a few times, and so we spent a fair amount of time working on that, and we don't have a draft yet. We're still a little ways away from that, but we've been exploring the option. And Roberta, maybe if you'd like to speak a little bit about the issue generally for the commission and talk a little bit about what we discussed last week as a committee.
One of the problems that we see happening here in Maine is that there is a standard to which roads are supposed to be kept if they're public roads. They're supposed to be kept safe and convenient for the public with travelers with motor vehicles. The wording has changed a couple of times, but I believe that's the current wording. And the state, I believe, has put out recommended standards for towns, which a lot of towns have adopted.
not really.
You don't know about that? Okay, because
Well, yeah, I do, but I don't know of any standards. That's correct. DOT doesn't put out standards for town roads.
okay, recommendations or something or other, I think, maybe. Anyway, whatever it is, a lot of towns have adopted that there has to be a standard where, in order to be a town way, it's supposed to have so many inches of coarse substrate, so many inches of fine substrate, so many inches of pavement, so many feet wide, shoulders, ditches. And it means that when there's a road that they can't keep to that standard, their only other option is to discontinue it so they don't have any responsibility at all. And we think there should be some in between because not every road has to be kept to that full standard. Gravel roads work quite well in a lot of situations. In Vermont, they have a huge number of gravel roads because they find they're cheaper to maintain in the weather conditions. And so we think that there should be some roads that can be kept to a lesser standard. And one of the solutions that a lot of Midwestern states have used is the minimum maintenance road. And what they do is they designate certain roads do not have to be kept to full town road standard, and they will designate what the road is for. There's, depending on which state it is, they have different categories. Some of them have seasonal roads, most of them have farm roads. But one of the things that we found in looking into this is that I think every single one of these states that has a minimum maintenance road category says that you cannot reduce the maintenance of a road to minimum maintenance if there is even one resident on it. So that kind of defeats the purpose of what we were looking for. We did find one state that has what they call remote residential roads. And these are roads where there's maybe just one house or a couple of houses, but they're out quite a ways. And it would be an expense for the town to have to maintain this long stretch of road to full town road standards. So what they do is they maintain it to a lesser standard. They have to be kept passable, but they may not get maintenance as quickly as full town roads would. They may be the last ones to get plowed, but they do eventually get plowed. And they can be gravel roads. And that's more what we're looking for. I've talked to various people who live on these roads who don't get any maintenance currently. And I've said, how would you feel if you got a little maintenance? Say if the town would come in and grade the road once a year after mud season, or if the town would put in a load of gravel in the worst mud hole each year, so gradually you improve the road. And the ones I've spoken to have said that would be terrific. They're not asking for a paved road. Most people don't move in onto a dirt road because they want to live on a paved road. So when they ask the town for some help with maintenance, lots of towns will say, oh, we can't do that because that would cost us $1 million to bring this up to town road standard. And that's not what they're asking for. I know when we first went to the town, we said, could you just give us a little bit of gravel? And they said, oh no, we're gonna have to fix the entire road and it's gonna cost $1 million. So I speak from personal experience when I say that. And I've heard other people who have had similar experiences. In one case, the town had said that if there were more than 4 houses on the road, that they would resume maintenance. And when the 5th house went in, they divided the road into 2 roads and said the north road is 1 road and the south road is 1 road. So neither one of them has that number of houses on it. So these are the kinds of things we see, and we're just looking for some solution. One of the things that we saw over and over again in the information about minimum maintenance roads is that it saves towns money and it saves towns liability because they don't have to keep all of the roads up to that full town standard. And that's what we're really looking for. We're looking to get some help for the people on these roads, but without breaking the bank for the towns. And that's why we were looking into some, lesser standard of road. And I know Rebecca will say that, oh yes, they can already do that under section 3105 of Title 23. But the problem is that most towns don't. And that if someone goes to a town and says, will you give me some maintenance under 3105? Usually the response they get is they either get ignored or said, oh no, we can't do that, or that doesn't apply, or they actually get laughed at in some cases. We were told that 3105A only applies after your house is already on fire. Oh yeah, we can bring the plow truck in front of the ambulance or the fire truck. And by then it's gonna be a little late by the time they get there. So our idea is to just, keep a fire lane open. Maybe in the winter, if the person who's plowing it can't keep it to full width, bring in the wing plow and push the snowbanks back so you still got a fire lane open. We're not asking for full-time plowing, but like in those remote residential roads, they may get plowed after everybody else, maybe. But even if they just get the wing plow to push it back if it gets to be too narrow. So those are some of the reasons that we thought this might work and some of the ideas we had for doing it.
And what the group also thought of, because, there were concerns about if this were mandated, you'd wind up with a fiscal note and do we really want to create another class of roads where you already have townways and public easements and private roads? Do you want something in between? And what the group was looking at was this concept. Let's create an option in the public easement statute where, right now the town has the right but not the obligation to maintain public easements, and each year you can go in and ask the town meeting to maintain, and they'll decide what level of maintenance that is. But that's not a real guarantee for anybody who lives along that road. It doesn't say that for the next 10 years you're going to have this level of maintenance. It doesn't say what the level of maintenance is. Is it just summer? Is it summer and winter? What does it look like? So what we were thinking of is building on that idea of remote residential, where there's one or more people living on a road. They can approach the town and ask for this option of having a minimum maintenance, a remote residential standard. So it would specify a minimum standard that the town could go above, and it would be something that would be brought to the voters. So town meeting, or the county commissioners, the legislative body, would look at this and decide whether to allow this maintenance, whether it's the minimum standard or whether it's more. It would be an option for public easements. It wouldn't be another class of roads, just an option for public easements. So we'll be looking at that some more. I'm supposed to come back with a draft for next month's meeting. And so that group would explore this some more and then come back to the commission at its next meeting with a draft, so we can kick the tires on it and see if that's something we want to add to our list of legislation. So then,
One other thing, Jim.
yes.
One other point that I didn't mention is that I think in every case where there's a state that has minimum maintenance roads or remote residential roads, that they are required to post it to warn the public, so that the public doesn't see a plowed road and think, oh, this is going to be fine, I can use it, and then get in and find that it's not sanded, or what looks like a good gravel road and they get partway through and it's not as good as they thought it was going to be. If there's that warning sign, then that helps relieve the towns of liability.
You
might want to switch to four-wheel drive mode or something like that. Right.
Can I interject something?
Please.
Where we own our easement with the town of Frenchville, it's remote. There's no winter plowing at all. Okay. They only plow the beginning of from the Frenchville side, and same thing from the St. Agatha side. It's not plowed. Now, I already considered a minimum maintenance road because it's dirty, it's muddy, it's got potholes in it. You don't bring your fancy car there, and just that's what it is. Now, if somebody decided they're going to buy a little plot, an acre, and stick it out in the middle of that road someplace, and request minimum maintenance and expect winter plowing, that's a big deal for a town like Frenchville or like town of St. Agatha, either side of the border. It's the end of Montaigne Platte. There's nobody there. There's the other way. It's the woods, and so and we've already had lots of examples of people building in the concession. They call it up here the concessions, the government concessions, the back roads. We got tons of those roads for someone to go there and then expect the town to plow to their place is not feasible to expect. A lot of those people, if they're going to do that, they better have a little shed right at the base of like where it is plowed up to, and keep their snow sled in it or their snowshoes so they can go home. But they can't, in a small town, it's a huge deal to expect extra work plowing, especially since these people are required by law to remove snow. And if they don't do so in an X amount of time and somebody gets hurt, they're liable. They're already stretched thin. We don't have the resources for it. So that is, to me, one of the biggest issues is that people deciding, oh, in northern Maine, you can buy a piece of land for free. I'll buy an Amish cab and put it on there and I'll be there, but then I'll expect somebody to plow to me. And so I just wanted to throw that out there. Thank you.
And that's happening already to an extent, because on a public easement, where the town has a right but not the obligation to maintain, because the road's been discontinued or abandoned, there might be an abandoned farmhouse, and it's cheap, you know, and that's why the road wasn't used anymore. No, it was abandoned or it was discontinued because no one was living there anymore, but there's some cheap property, some old houses that you could rebuild. Or the land might be cheap generally because of that. There may be no residences now, but the land's dirt cheap. So we've been seeing that throughout Maine, and suddenly people build it and say, well, why can't the school bus come by and pick up my kids? Because the school bus doesn't go down anything but a town way. But can you get a building permit? Yeah. Why? Because the definition of street or road in most zoning ordinances is a road where there are public rights. Public easement is still a public right. It's public right of access. Doesn't mean that the school bus is going to be able to get down there. It doesn't mean that the town's going to maintain it, but there's a public right of access. So you do see people building in these public easements. And so the idea here is not to create an expectation or a false expectation, but to allow, if people have built out there or are building out there, or if the town is issuing building permits, these people can ask the town meeting to decide not only to maintain it to a certain level this year, but to have a reasonable expectation that until the town meeting reverses it, this stays in effect, and I will get this minimum level of maintenance, or maybe this minimum level of maintenance plus, but as decided by the town at its option. So it's not a mandate on the towns, it's an option, but it provides it provides for a definite decision so that both the town and the resident know what to expect.
As long as it can't be overturned easily, you know, you want to make sure it's binding for a certain period of time, for sure.
Well, yeah, binding until the town meeting reverses it. As all municipal ordinances and decisions are. They're binding until a town meeting votes otherwise. But to have to go back each year doesn't seem to make sense. I mean, that's the way it is now. Nothing's definite in that sense. It invites disputes and fussing and fighting. So that was the thought, and that's where we're working toward, but certainly welcome your comments and thoughts on those ideas.
As far as the plowing goes, we weren't necessarily saying that every town that takes this on has to plow all winter. We were suggesting that in most of these cases, the people are already plowing it themselves. But if it comes to a situation where the road is getting so narrow that a fire truck couldn't get in there, if they could maybe ask if they just make one pass in and out with a wing plow. They could just say, no, that's not part of the agreement. They could say, all we're going to do is grade it in the spring once. It's up to the town to decide what level of maintenance they're going to agree to make available. And, you know, some towns may have the ability, or there may be just a short length of road and they say, yeah, we'll plow that a couple of times, or, you know, we'll grade it, we'll put in a little bit of gravel. But if it's a long stretch of road, or if it's a small town and they don't have the funds, they can say, no, sorry, all we can afford is X, Y, Z, whatever.
But we may want to specify a minimum level so that if the town decides to choose this option, there's at least public safety provided for. And there won't be a liability for the municipality, but we'll at least keep the public safe.
And that's part of where the signs come in, is that the signs warn people that they shouldn't expect it to be like a town road.
That's part of it. Yep. So what do we all think?
Also, what you're mentioning, though, like what Roberta was mentioning, and is specifics, right? Like Making sure that it's not an impediment to emergency vehicles is one of the things you just mentioned. To me, like, and it was mentioned about the town potentially adopting certain standards, but it is all about the standards. And even though there's half a dozen of them, one might be that access to emergency vehicles. Like she mentioned about the gravel available, right? Well, specify. They'll be allowed to be able to access X amount of gravel annually per mile or whatever, but to me, you need that specificity as far as this kind of stuff goes, when you're talking access to emergency vehicles and occasional care, there should be a metric on it, in my opinion. Thanks.
That's what I had in mind when we talked about, a baseline, minimum standards, that if you're going to adopt this option, you use these. And we'll look at the remote residential standards and see if that might provide us with something that's concrete or gravel. Okay. Other thoughts? Okay. So, let's see. Not to be outdone, the group 3 is looking at terms. You may remember when we started this last year, we've been given 4 terms by the legislature and told to work on those, define them, and try to diffuse the confusion that's out there. And we thought probably the most confusing term, when you look at public road, private way, public easement, private way, because it sounds like private road, but we know that it really is a lot more than that. So we started looking at the idea of coming up with a definition of private way and some changes to state law to make it clear when things are a private road with no public rights and when things are a private way which has become a public easement, so that we can we can try to eliminate that confusion or reduce it as much as possible. So we're working on a draft, and that will be discussed at the next month's meeting. So I'd say stay tuned for group 1 on minimum maintenance and group 2 on private way, group 3 on private way. We will be back to the commission with drafts for discussion. And if we get to, I hope we can get to a place where we can pass those along to the legislature. We can come up with some drafts to try to dispel that confusion. So I'm thinking that we should schedule a meeting for probably, 3rd week of October to give the committees time to meet and give me time to draft. And so we can have that back in time for this board to, this commission to meet. 2025 is coming up, and we owe a report. So that's something that Heather and I will start working on as well, so that we can talk about what this commission has accomplished this year, what we've tried to do with our groups, and the draft, and explain the draft legislation that we'll be putting in that report. So that's something we'll be drafting as well. So the idea is that in October, anything that we're going to put in the report for draft legislation, we want to make sure it's ready. If it's not ready, then we kick it over to next year. But let's see if we can refine all those ideas so that we have a report that explains what we've been up to, the reasons why we're recommending these changes in the draft legislation. And that way, if we can get that going in October, it'll give everyone on this commission time to report back to whomever you need to. Say, here's what's going to be in the report. Is it okay if I vote yes on this, so that we can try to make sure that we're unanimous in everything that we do tell the legislature we propose to do. So that's my timetable and set of goals for this commission to get us to have a good report and make some progress this year that we can present to the legislature. Of course, they haven't given us the money that they said they were going to, but that's okay. We're not in it for the money. It would be nice to have mileage paid for or something, but here we are, and that's where it is. So any thoughts on that timetable and those goals?
Jim, I have a question about maybe at the next meeting, I'm wondering if we might take stock of where we are with the items that the legislature asked us to report back on this session, because I've sort of lost track of what we've done on some of them. And I want to make sure, I don't recall that we've done number 4, but I could be wrong. So I'm just wondering if we might have that kind of conversation at the next meeting, where we just look back at that legislation and make sure that we've fulfilled our obligations under it.
Absolutely. We'll put that on the agenda. So we'll get the committee reports. We'll look at where we are with regard to that. And that also is going to come into play when we're talking about writing that report, because we'll have to recount what we were asked to do, and where we're at. I think we get to number 4, but we'll make sure we pin that down. Other thoughts, comments? All right. I will prevail upon Heather to do her doodle polls for us, or to get the timing together. But I think around the 3rd week of October would probably be good to shoot for, if we can have the committee meetings before that date so that we have something to provide. That would be pretty useful, and we'd be able to, I think, make a good stab at making some substantive changes that will be helpful, and proposing that to the legislature. All right. Great. Well, thank you. Motion to adjourn? Come on.
So moved.
Okay. And a second. All right. All in favor? We'll just do this without a roll call. Show of hands. Aye.
Aye.
All right. Thank you all very much for your help this afternoon. Talk to you next month and see you in the committee meetings.
Thank you.
Thank you, Jim.
Thank you. Nice job. Thanks.